Good afternoon, everyone, and welcome to the Senate Judiciary Committee meeting of April 9th, I believe, 2024. I think I'm still on the eclipse kind of thing. So can I get a motion to move into executive session?
So moved.
Moved by Senator Whitley, seconded by Senator Gannon. The last Senate bill that we have is Senate Bill 422.
I move ought to pass.
Okay, Senator Whitley moves ought to pass. I will second. We do have an amendment. It is 1424S.
I move ought to pass the
Okay,
amendment.
Senator Whitley moves ought to pass. I will second. I'll speak to the amendment. When this bill was heard, we heard from people across the state that were very concerned that the words mother and father were taken out. So we've worked with the folks that have asked us to bring the bill in to put mother and father back in and combine the language. So that's why we have this amendment. We did get an email yesterday from one of the attorneys, and we will have to get a committee amendment. And so I'd like to propose a committee amendment to you, Matthew. We need to insert the word mother on page 10, line 10, and on page 11, line 17. And so I would like to move that amendment.
Second.
Pardon? Yes, birth, excuse me. So it's birth mother on page 10, line 10, and birth mother on page 11, line 17. Okay, so it's been moved and seconded. Does anybody have any questions or comments? Senator Abbas?
Madam Chair, I just want to thank you for putting this together. You know, there was a lot of strong opinions coming in all sorts of directions, so to get everyone on the same page.
Yep. So this bill will still accomplish what it was intended to. And we've satisfied, I believe, the individuals that had a problem with the removal of birth mother and birth father.
Great.
So, yes.
I'm not sure that I heard the amendment you're proposing, the committee amendment to make the corrections that. The addition is not the word mother, it's the word birth.
Correct.
Yes, Matthew corrected me on that, so. Okay, so we have an amendment, a proposed committee amendment that inserts the word birth prior to mother on page 10, line 10, and on page 11, line 17. Okay, are there any further comments or questions? Okay, seeing none, all in favor say aye. Aye. Any opposed?
I
Okay.
move ought to pass as amended.
Okay, Senator Whitley moves ought to pass as amended. I will second it. Is there any discussion on the bill as amended? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, is there a motion for the consent calendar?
So moved.
Moved by Senator Whitley, seconded by Senator Chandley. Is there any discussion on the consent calendar motion?
Senator, it'd be easier if it was left off the consent calendar for the addendum.
Oh, because it's the addendum.
Yeah.
Okay, all right, so, will you withdraw? Okay, so I will take this one out, Matthew. Okay. Okay. Thank you all very much for this. This was our very last Senate bill. So,
Congratulations.
I know, thank you to all of you because it was an incredible amount of bills that we've had, but we got them done. So, can I get them? Pardon?
None of them are controversial either.
Nah, not a one. Okay, can I get a motion to come out of executive session? Moved by Senator Whitley, seconded by Senator Gannon. Okay, now we're going to go to our planned public hearings. We're going to open the public hearing on
But yeah.
oh, we were fast, okay. Okay, the committee will be in recess for 4 minutes. I thought we had gone beyond that.
So is the plan to put it on the calendar for Thursday?
And that's for 4:15.
Okay, thank you. I was just going fast. I was just going zoom, zoom, zoom. So we're good. Seeing it is now 1:16, the committee will come out of recess and we will open the public hearing on House Bill 1038. Representative Verville is not available, but I see Representative Katab is here to introduce the bill. Good afternoon, Representative.
Good afternoon, Madam Chairman and honorable members of the Senate Judiciary Committee. As Chairman Carson stated, Rep. Burville isn't here, so I'm Representative Caitlin Kutab here to introduce House Bill 1038 relative to prohibiting registered sex offenders from employment at businesses providing direct services to minors or direct supervision or oversight to minors. This bill has passed the House a few times, including last year, and then it was referred for interim study in the Senate due to some language concerns that Rep. Lynn had testified to. This year, Rep. Lynn worked with Rep. Verville on the language to ensure that the bill is good to go. The bill had no opposition in the House hearing, as all the issues have been addressed. And Rep. Verville did pull all the research from last year to ensure that any concerns were addressed for the bill. The bill is simply closing an unintended loophole in New Hampshire law as found in the 2019 State of New Hampshire versus Proctor case, where a landscaper was able to hire a minor to work with him at times when they were alone, unsupervised. The only concern that had previously been raised was relative to a shortage of jobs and concern that sex offenders may not be able to get a job. This has been carefully worded to ensure that jobs such as bagging at a grocery store would not be included. And we don't think that that will be a concern, as New Hampshire continues to have extremely low unemployment numbers. So it's highly unlikely that this would have any impact on that population. And I would urge the committee to vote ought to pass on this important piece of legislation so that we can ensure that we're keeping our children safe. And I'm happy to take any questions.
Thank you very much for your testimony, Representative. Are there any questions for Representative Katab? Representative, you quoted a case. Could you please repeat that?
Yeah, so it was the 2019 case, State of New Hampshire versus Proctor. And in that case, it was basically decided that it was overturned that he shouldn't have been working with this minor because it was stated that although that might have been the legislative intent to prevent unsupervised working with a minor, that's not actually what the statute says.
Okay.
So his conviction was overturned based on that purpose.
All right. Are there
And I'm
any?
happy to give this copy over so he has.
Thank you. Are there any further questions or concerns for Representative Katab? Okay, seeing none, thank you very much.
Thank you.
Okay, are there any other members of the public who would like to speak to House Bill 1038? Okay, seeing none, we'll close the public hearing. The committee will be in recess until 1:30. Okay. Thank you, Matthew. Yeah, well, The committee will come out of recess. We're going to open the public hearing on House Bill 1012. Representative Cushman, the prime sponsor of the bill, is not able to be here today, and Senator Abbas has graciously offered to introduce the bill.
Thank you, Madam Chair. I'm Senator Darrell Abbas. I represent District 22, the communities of Pelham, Salem, Exon, and Plastow. The prime sponsor of the bill, who I believe intended on appearing today, had a family issue and could not make it. So I just ask that don't hold her non-appearance here today against the merits of the bill. But I'm taking no position, and that's all I have to say. I'll defer any questions.
Okay, thank you. Are there any members of the public that would like to speak on House Bill 1012? Okay, seeing none, we'll close the public hearing, and the Senate is in recess until 1:45. out of recess, and we are going to open the public hearing on House Bill 1002, and we're going to call the prime sponsor, Representative Kitab.
Good afternoon. Thank you, Madam Chairman and honorable members of the Senate Committee. I'm Representative Caitlin Kutab, and I'm here to introduce House Bill 1002 relative to fees for records under the Right to Know law. House Bill 1002 was carefully amended in the House with members of the committee, Right to Know New Hampshire, the New Hampshire Press Association, the ACLU, and NHMA to reach a balanced solution to a complex issue. What it does is it allows the public bodies, enables them to, by passing first in their town a policy so that these are uniform and consistent, to charge for electronic communications / emails in excess of 250 communications up to $1 per electronic communication. Part 1, Article 8 of the New Hampshire Constitution specifically states that governmental records shall not be unreasonably restricted. However, the current terms of the Right to Know law do nothing to define what is reasonable. This bill seeks to help provide that balance so that we don't have taxpayers subsidizing one company's large request or one person's crusade. Extensive requests tend to be for large-scale emails, which are often never even picked up. And it requires an attorney who's usually not on staff, especially in smaller towns. It's usually contract attorneys that are paid $400 per hour to go in and redact these emails, because remember that Right to Know also applies to public schools. So we may have private student information in these emails that do need to be redacted, and it's quite costly, especially considering that when this person requesting the records may not even live in this district, so they're not even paying a portion of what the other taxpayers are paying towards to foot this $10,000 bill for redactions. And so after doing careful research, 42 other states do have provisions that allow for charges for research and redactions and whatnot. And those laws are all much more stricter than what this seeks to impose. So I think it's a very reasonable solution to this issue, and I would ask that it not be amended, because again, it was carefully kind of crafted and worked out amongst many of the stakeholders, and I would be happy to take any questions.
Thank you very much for your testimony, Representative. Are there any questions for Representative Kitab? Seeing none, thank you very much.
Thank you.
The chair will call Representative Chuck Grassi.
Thank you, Madam Chairperson. My name is Representative Chuck Grassi from Stratford District 8, which is Rochester Ward 4. I'm here as a co-sponsor of the bill, and I think that when you take a look at what this bill does, Rochester, it's sort of like the horse has already left the barn in some cases. I had a meeting with the mayor this last week. We've had a long history of excessive requests at city council, at our city hall. We actually have a position in our budget. We're going to spend about $70,000 to hire a person just to deal with Right to Know request. I think that is, unfortunate. Hopefully, this bill will make that position just a short timer, and that we're able to do things that will allow the municipality to dig down a little deeper on what some of the requests are, and be able to refine those requests so we're able to provide them more efficiently and more specific. I actually met with one of the department heads this week, and he says he's required at the end of the day to go through and to actually print out all his emails dealing with the mayor and certain department heads within the city. It takes him about 15, 20 minutes at the end of each day to go through, and every email that he sends out and every email that he receives has to be printed out and submitted because they're under a 91A request in his department. So I'd be happy to answer any request, any questions.
Thank you very much for your testimony. Are there any questions? Representative, you just mentioned that this department head has to, because of the 91A, they're under 91A, they have to send them out? Does this individual who requests paper copies, do they come and get them? Or what happens with them? Do you know?
Well, I don't, and I didn't really talk to him about that. I didn't get into that point of, I was just sort of saying, you're kidding me, is what my first response was. But I will tell you that through our school department, and I have some real familiarity with what's happened in our school department. We've had a number of requests there, and I actually visited the school department. They pulled out a drawer, and it was full of thumb drives and stacks of paper that had never been picked up.
Thank you very much for your
You're very welcome.
Next, we're going to call Catherine Coco. I think that's how it's pronounced, K-O. Okay. Good afternoon, Ms. Coco.
Good afternoon, Madam Chair, members of the Judiciary Committee. My name is Catherine Coco. I am the president of Right to Know New Hampshire. We are a all-volunteer grassroots organization of loosely affiliated individuals who have an interest and experience with the implementation of the Right to Know law and have been weighing in on legislation since probably 2012. We have decided not to formally take a position on HB 1002 because it does create limits on access to public information, something our group does generally not support. However, this bill is the product of a very difficult negotiation process in which we determined that if implemented, the solution suggested here was one that we could reasonably live with and was not counter to the spirit of the Right to Know law. I just wanted to recognize a couple of things while we were here. As a loosely affiliated coalition, we've really worked hard with this group that included the ACLU, the New Hampshire Press Association, the union leader, and somebody I'm probably forgetting right now, to get to the heart of what the primary concern was, and really with the bill's sponsor and a couple members of the Judiciary Committee to try and make sure that we addressed those while still protecting the public interest, and the scope, limiting the scope of this bill in a way that had not been initially limited. So now it is limited to the records that have the most potential to be the most problematic. So for that reason, we've decided that we're not going to take a position on it. I do want to make sure that for the record, the negotiated solution was focused, as the language in the bill includes, but doesn't indicate that it's exclusive to, emails, texts, and chats as the definition of electronic communications. I have had a number of people ask me questions and come up with scenarios where they thought other things could be electronic communications. The purpose of this is emails, texts, and chats as defined in the bill. And so I want to make sure that's preserved for the record if legislative intent is ever questioned. And then I would also just emphasize that I try to carry this message across to any committee that I testify in front of on Right to Know, that in New Hampshire, individuals have a very unique role in ensuring government transparency. When we compare New Hampshire to other states, especially those who do charge fees, which, as Representative Katab said, does happen in other places, it's incredibly important to note that our law is entirely and uniquely reliant on private action for enforcement. That is one of the reasons that we received a low grade on public access to information as defined by the Center for Public Integrity in 2015. And so even with the creation of the Ombudsman's Office, I don't feel that that rating would change because investigations into public access to information still have to be implemented by individual citizens. So that's something that is fairly unique. We don't have an infrastructure in place that is overseeing transparency in New Hampshire. And so I think that's something that we have to keep in mind every time we make a change to RSA 91A. And with that, I'm willing to take any questions you may have.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none. Thank you.
Thank you.
Okay, the chair will call Nate Graves.
Thank you, Madam Chair, and H. Grace for the Municipal Association. We strongly support the bill in front of you. I think you're going to hear a lot of the same today, I hope. I do know that you received an email from Joe Bissonette of the ACLU repeating the same. As his email stated, we believe this is a good compromise. Stakeholders came together, hammered out something that could make the the right to know bill, the right to know law more collaborative for requesters and the government. We think that's incorporated as well as provide a local option to deal with the requests that cost the most money. The only thing I do want to emphasize is that just on that cost aspect, during the course of discussions while we were data gathering, we did receive some data on what law firms charge to redact records. Those are up to $400 an hour for the town of Londonderry. So this, even if a local option of a per electronic communication charge was implemented, we don't anticipate that would cover the full cost of those redactions, but it would provide for some skin in the game to help encourage requesters to talk to the government and really think about what they want to request, and make sure that everybody can get the stuff that they actually want and hopefully get it faster than it is currently processed. I'm happy to take any questions the committee may have.
Thank you very much for your testimony. Are there any questions from the committee? Senator Abbas.
Thank you, Madam Chair. If you look on page 1, and it starts on line 28, which is basically section F. And then it goes into page 2 that ends on line 5. It basically talks about, I would say, like an inadvertent disclosure of information that should not have been disclosed, and for whatever, it wasn't redacted properly. What kind of information would that be? I don't know if you can give me an example of that.
So Section F was created for the purpose of hopefully future-proofing the law. So what we're seeing, especially with the sort of automated redaction technologies that Adobe's incorporated in their reader and everything, is that if you have a number of documents that are basically all the same, it can go through and automatically redact those. If something's scanned slightly off and so you miss part of it, like part of somebody's address or something that you're supposed to be redacting, and that inadvertently gets disclosed, there would be a liability protection there. That's what Section F is intended to do. It's supposed to encourage that use of that technologies. Obviously, it's set up in a way so that you have to use it I don't remember the exact wording and I don't have it in front of me, but in a manner that you're setting it up so that any reasonable person setting it up would set it up in that way, so that you can't just run this software with no refinement. You actually have to go through, look at it, do spot checks, everything you would do normally to make sure it's actually doing what it's supposed to be doing. If you don't do that, if you're not doing those checks, then you wouldn't have any sort of protection that's included in Section F. So that was a good balance that comes from I'll give my credit to my friends at the ACLU for coming up with that.
Thank you.
Thank you.
Are there any further questions? Seeing none, thank you very much.
Thank you.
Okay, the chair will call Brendan McQuaid.
Good afternoon. My name is Brendan McQuaid. I live in Manchester. I'm the president and publisher of the New Hampshire Union Leader and the current president of the New Hampshire Press Association. As has been mentioned, we were one of the stakeholders that helped to amend this original version of the law. I have to say, we don't love the idea that we're going to charge for records. That's not a great thing, but this represents a compromise that is livable for members of the Press Association to get the records that they need. It has a pretty wide latitude for electronic records, but still allow the towns which express that, these emails are just a bear to deal with, to be able to have a mechanism to charge for those. I will also be speaking on 1069, which I encourage you to look at in tandem with this one, because it presents some interesting situations. But other than that, I am ready for any questions.
Okay, thank you very much for your testimony. Are there any questions for Mr. McQuaid? Seeing none, thank you.
Thank you.
Okay, the chair will call Julie Smith. Good afternoon, Ms. Smith.
Good afternoon, committee. Julie Smith from Nashua, the right to know hellhole of New Hampshire. I oppose this bill. City Hall is riddled with non-transparency, which is a symptom of dishonesty, to borrow the words of someone here in this room. If you don't think this political cancer is coming across the Merrimack River to a town near you, think again, because it's already there. Just look where this bill originated, meaning the idea it spawned from and took root. A town already well known for locals who balk at investigation, such as in the addressing of its election irregularities over the past few years. The institution of the carve-out is nothing new to the legislature, and I fully expected it to be a selling point used in this bill's introduction. But to that I say the following. No matter how much a bill is amended, passing it is still planting a bad seed. It opens the floodgate for future perversions favoring tyranny. It unlocks the Overton window. It's a foot in the door, to use psychology parlance. Furthermore, when I hear about voluminous nuisance requests, it's disingenuous fear-mongering to the rest of New Hampshire when such cherry-picked examples could be handled at the local level. As the words I've heard many times in the Senate chamber and in committee videos, it's a solution looking for a problem. I don't support compromise because I just explained why an all-or-nothing approach is to be taken with this bill. Please don't open the Pandora's box that potentially chisels away at freedom of information. On February 8th, the day the House sent this bill back to committee, it was plain serendipity that Kelly Ayotte was stumping at Sky Meadow that evening. I raised my hand after her speech to ask her to weigh in on HB 1002, considering she's an ex-attorney general after all. She told the room full of attendees that she was not a fan. The fine gentleman and the chair have received plenty of emails from me, and so has Attorney Lehman, who has considerable firsthand knowledge of our local dysfunction. But I want to utilize this opportunity to briefly point out a few more of City Hall's right-to-know shenanigans. One of them is the hiring of right-to-know coordinators and treating all ordinary questions being asked as right-to-know requests, thus padding the numbers of right-to-know requests the city claims to be allegedly bombarded with. Do not let the mayor and his fan club fool you. And lastly, the implementation of the Citrix portal, that anything flagged as a right-to-know request gets corralled into, and it's consistently malfunctioning. All by design, I'm convinced. Any bill creating obstacles to loopholes is subject to malicious exploitation, which I agree with Ms. Coco on the obstruction of access to information. This is a bad bill and only aggravates the present situation. Please do the right thing to kill it. Thank you, Madam Chair.
Thank you very much for your testimony, Ms. Smith. Are there any questions for Ms. Smith? Seeing none, thank you. The chair will call Lori Ortolano. Good afternoon, Ms. Ortolano.
Good afternoon. Thank you for giving me the opportunity to speak with you. I am representing myself here. I'm a member of Right to Know, but I'm going to express my opinions as an individual. I'm strongly opposed to this bill. I live in Nashua. I'm the person who, in fact, was part of probably the reason the bill was created. And I don't think it was done for the right reasons. You know, we're facing tremendous difficulties in Nashua when it comes to right to know requests, and it's gone on for a long time. You know, right to know requests have become a criminalized activity. And when I look at this bill that says 250 emails can be given and within a month, and then anything over it would be $1 a page. My 75-year-old friend won her court order to get emails between two assessing managers and the city, with a newly hired right to know attorney, produced 900 emails in a month for her and gave her the whole batch. This would now cost her almost $700 in a fee if she took them in a month. She'd have to tell them, divide it out over 4 months because I can't afford that. That's expensive. I think $1 a page is way too high. And when you look at some of these emails that are individual emails, you're getting a page with 3 words on it that make a sentence. Buck a page, that was looked at, sent electronically. I'm in a situation where we're dealing with an art center in Nashua that I got into trying to understand the financing of it. It turned out to be a public-private partnership, turned out to have a lot of nefarious issues going on. I put in a request to get all the emails on this federal new market tax credit program. I received a response, there were 1,200 emails. I figured, okay, it'll take them 4 or 5 months. 6 months came, they were still batching. I kept writing to them saying, what's the update? Because they said when they found 1,200, they would keep me posted on when it was done. 5 months, they never kept me posted. So I said, what's the status? They said, oh, we found another 1,800. And it's gonna take us 4 years to get these to you. That's a long time. And they were batching them out essentially in little bits of, 60 emails a month. I'm going to be slogging through this. And what killed me were attachments. Attachments to emails sunk me. Because while there were 3,000 emails, the attachments made up 20,000 emails. Okay? And when I put in a request and said, I don't want the attachments, they refused to change. I'm in court right now with a lawsuit before Judge Temple over the fact that I put in my Supreme Court order where I won up at the Supreme Court, the backup tape emails. The city told me there were 1,000, 1,200 emails. Then all of a sudden they showed me that there were 6,000 attachments. I said, oh, for assessing, I don't want the attachments. Don't give them to me. Well, we have to. They're attachments. And we have to review every page, exempt every page, redact them, and incorporate them, page them, and incorporate them into the order. So now my 1,200 pages is 7,500 pages. Well, that does create a lot more work. Meanwhile, my mayor is writing letters up to you folks saying 2 people in Nashua have cost us over $1 million in the last 4 years. That's because they don't work with us. We have no avenue to communicate. Nashua has put locks on virtually every city office door, even if they contain public records that are supposed to be accessible during normal business hours. The purchasing office, which has all of the contracts for city work, which used to be an open office you could go into and request a contract. It has got 3 locks on it. It's like Fort Knox with a camera. Not accessible. You can't ask for a record anymore. Not permitted. It is so stinking corrupt in there. I never thought I would see what I've seen and to have to fight what I fought. And a bill like this just kills us. And Judge Temple he's trying to get mediation done to try to figure out what to do with these attachments, but no surprise, no mediators are available to work with us. So into court we go. But I tried for months to get the city to back off on the attachments. And this attachment issue only became an issue 18 months ago. Prior to that, when I was doing my right to knows and getting emails, the city never gave attachments and in fact would write a letter responding saying, we're giving you just the email. If there's an attachment you'd like, let us know. And that's how I always did it. Then all of a sudden attachments, these new market tax credit emails I want, 20,000 pages of attachments. It's taking years. And they hire right to know administrators and coordinators. They hired a new right to know administrator 18 months ago. They put him in a locked office behind a closed door with no office hours, no name tag, and no phone. I mean, is that what you do with somebody who's supposed to be assistive for public records? That's absurd. I'm just so discouraged. And I know Nashua is a Democratic city. I wish you'd carve us off and throw us into Massachusetts because I think I'd be a lot better off because I can't get any state assistance. And sadly, I'm not a Democrat or a Republican anymore. I'm not a party-affiliated person. I just wanted my records. And I think that a lot of the things I asked for were materials that are of public interest. The following on the Arts Center is pretty big now. And I feel like I've stood in the face of corruption. I've seen everything I want to see at 62 years old. And I've lost all faith in the judicial and legal system to adjudicate anything or the state to legislate anything that could assist us in New Hampshire. I hope the whole Democratic wave just sweeps north and we all are in the same party together and then we figure out how to deal with this. because I don't have anyone to go to get assistance anymore, and no one in Nashua does. The whole legislative system and judicial system has been a huge disappointment, and this bill is going to close down more records for us in Nashua for sure. It's going to create a huge financial hardship. Thank you.
Thank you very much for your testimony, Ms. Ortolano. Are there any questions from the committee? Seeing none, thank you. Ms., I think it's Pele? Yeah, do you, you have a question mark. Did you want to speak?
You said what I was gonna say, I wasn't.
So do you want to come forward? Okay, please, and make sure you identify yourself.
And I've never spoken before the Senate before, so I
That's
get all
okay.
choky. But I am a GenCourt junkie, and you've all gotten emails from me in the past. I'm Maura Annette Chappelle. I represent nobody but myself. I joke that I'm the self-appointed ambassador to Coos County because we are like the forgotten people up there. I wasn't going to come today. I wrote my stuff as the others spoke. At the last second, I decided to go through the Eclipse traffic that was still on its way down from Jefferson. I know I talk fast, but I'll try to go slow. I hope you senators, if you haven't already, that you go before you exec, that you're going to listen to the previous hearing, executive session, another session, the other executive session, and then the final session, and read all the emails and written testimony that was already submitted on this. I hope you're not going to make a decision based on only what was presented to the Senate. I don't mean that to sound insulting at all, but I was listening to some of the hearings on the way down, and there was just so much that even I had forgotten. I know that this bill as written is better than the original, but I still want it to be ITL'd, and then next session, write a new one, and then tackle the big businesses, because that seems to be the only real problem, is the big businesses wanting all the plan and records so they can market solar panels and stuff like that. And when I say business, I do exempt the media as a former member of it and probably future again. So, but as to the people part of this, and Coos County has no newspapers. Well, we have one, and it does like the sports. And if you submit something, they'll publish it. So it's on the citizens to be our own little watchdogs there. And the studies have shown that the lack of, every time a newspaper closes, a local newspaper, like Rochester has, whenever one closes, within 2 years, property taxes go up because the board members know they can get away with more shenanigans because no one's watching. So I'm watching. But the onus is on the citizen. Whenever there's a problem with the 91A request, the onus is on the citizen to go to court or the ombudsman. To go to court is $250 plus possible attorney's fees, but it should be the reverse. An ombudsman option is one man serving over 1 million people, and his office is only possibly open for another year. So what happens after that? If this bill passes, the average hotel worker who loses their job because a business refuses to accommodate them when they return from surgery is hardly able to afford a lawyer or to be their own lawyer. Another problem with this bill is that everybody thinks town hall, town hall, town hall. Everybody's just talking about envisioning this lowly little clerk trying to do all this work. But it's New Hampshire Human Rights, which charged me $100 for my own emails. I had requested the inter-office ones where they talked about my case, because they would say, well, I talked to so-and-so and he said this. I asked for those. They charged me $100 for my own emails. So I have to take them to court because that request would have been part of these electronic ones. It also includes Department of Labor, who, by the way, I was the hotel worker, surprise. The Department of Labor sends everything zippy quick. I won that one, go figure. The ones that hide the information, you lose. The average person loses. I was a hotel worker, I was a bartender, I made a lot of money. I went to college. What about the bilingual cleaning person that loses their job? They're not going to human rights. And if they do, they're not really, when they go to human rights, they're not going to know how to navigate that. I got as far as I did, and I still lost. Unemployment Office, Department of Transportation, which has over 12 outstanding right to know requests from me for about 4 years now, and they're just starting to trickle in. In the past, though, they've sent me the wrong information, seemingly on purpose. I get Franconia stuff. I specifically want one stretch of road in Jefferson. That's all I want. It's all I've ever asked for. And I get Franconia stuff. And downstate towns I've never even heard of. And then they put it on a format that you can't use your smartphone, to have to go to the library and use the computers there. Human Rights also sent me my digital hearing, on a format that nothing plays it. It's not playable. I cannot listen to my hearing because they gave it to me on a format that doesn't do anything. So it's just not just the little town clerk, but even with the town clerks, not all of them are friendly. I don't mean to ramble. I just, like I said, I wasn't totally prepared. I have several requests in on behalf of my town. Like, our police budget keeps going up. We don't have a police department. So I have a new 91A in that. And I've also got 91As in because other people are afraid of the town. They work for the town. They don't want to lose their hours. Their husband works for the town. We used to have an arsonist. He still works for the town. Everybody's afraid in these little towns. And this bill is really for the big towns. It's for Newmarket. It's for Nashua. It's for Londonderry. It's for Rochester. In the little towns, we don't need this bill. And I know I'm rambling, so I'm going to final with this. With the electronic communication, I already object to the copy fees. $1 for a piece of paper. But the electronic communication fees in this new version, we've already paid in our taxes for the computers, the apps, the softwares, the printers, the copiers, the paper, and the ink, and we've already paid for the staff. I don't think we should be charged a penny for any request, period. So I object to that wholehearted. And I've got more, but I'll probably throw it in an email.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much. And the chair will call Russin Chester.
Thank you, committee chair. Thank you, committee members. Because of time, I'm not going to be asked to be put under oath, but in the future, when I come before and testify, I am going to be requesting that I be put under oath so that my voice has the same weight that everyone else seems to in these hearings. I am very much opposed to this bill. This is a situation where we are saying that because of a few frivolous 91As, we're going to punish the general population. I listened to this today. I've listened to almost all the previous ones. And the bottom line is the citizens oppose this bill. The lobbyists, the people with financial backing to benefit from this bill are supporting this bill. That alone should raise huge red flags for every single representative that has been elected into a position. Your constituents do not want this bill. It's very, very clear. That is one of the things. One of the other things I've heard is it's a good compromise. How's compromise been working for us? Let's just take a look at that. I used to believe in compromise. Now I say, look behind the intent. What is the intent of this bill? The intent of this bill is to keep the transparency unattainable for the regular taxpayer. And my property taxes should already be paying for this. If you don't have anything to hide, why would you pass a bill that would help destroy transparency? That would give more rise to lack of integrity. My town of Bedford, New Hampshire, had huge transparency problem, irregularities, illegitimacy, huge problems with the elections. And nobody was held accountable or responsible for that because it was an appointed position, not an elected position. Now, my town has an individual who is an elected position in a town position who is a lobbyist here at our state office. Do I trust that individual? Do I want to be able to have access to 91As if I think that that individual is doing anything that is against my constitutional rights or my rights as a property owner? The fact that this would prevent someone like me, who is living paycheck to paycheck and fighting like crazy to find ways to pay my property taxes, that would disallow me the opportunity to hold people accountable and responsible in my town. The issues with transparency in this state is getting worse and worse. A bill like this basically throws in our face, we don't have to be transparent. We're going to pretend that we're going to be transparent, but we're going to make it almost impossible for you to prove that we are not, that we are less, that have less integrity than we should. This bill should be inexpedient to legislate, if for no other reason, because it is against the citizens of New Hampshire.
Thank you very much for your testimony, Ms. Chester. Are there any questions? Seeing none, thank you, Ms. Chester. Okay, are there any other members of the public that would like to speak to Senate Bill 1002? You are?
Anne-Marie Timmons.
Okay, please come forward.
Thank you for the chance to speak. Anne-Marie Timmons, I live in Concord. I'm a reporter with the New Hampshire Bulletin. I submitted written testimony in support of this bill. I wanted to clarify something just for the committee. On page 2, beginning on line 12, it's important, I think, to clarify that a single message, not every message is charged. If there's a communication, everything in that under that same subject line counts as one communication message. So if you have an email and then an email replied to that and an email replied to that, that's not 3 messages. That's going to be 1 message. So I think there may be a misunderstanding that each of those is going to be a charge. It will not. It's not going to be the expense that's been described. And there's also, I just want to make sure the committee is aware that there's exceptions from the fee for indigency, the media, and information that's in the public interest. I've been filing right-to-know requests for 25 years as a reporter in the state, and I think this is a fair bill. I think towns are up against a lot of frivolous lawsuits. I think it's expensive for them to redact, especially when they have to hire it out. In this field, as part of the team that compromised on this, and I think it's very fair. But I do think I would encourage the committee to really spend some time with page 2, lines 12 through 15 to understand how this would be charged.
Thank you very much for your question, for your testimony. Are there any questions? Ms. Timmons, before you go, we had testimony from Ms. Ortolano about the number of emails that she's requested, and many of them have attachments. Sometimes the attachments are more than the actual emails. Under this legislation, those attachments, and it says, attachments to electronic communications shall be considered part of a single communication. So if this passed, they couldn't charge an extra fee for any attachment to any email. Am I correct?
That's my understanding. That was the understanding in the conversation that we had. And this resets every 30 days. So in a month, you can file again, and then your clock is reset. So I know it's not ideal for people. The idea of charging records is disturbing. I understand that, but I think we have to be realistic. It costs a lot of money, and I think this is a fair compromise to resolve that.
Thank you very much for your testimony. Okay, are there any other member of the public that would like to speak to House Bill 1002? Okay. Seeing none, we close the public hearing. Oops. Oh, my. Got it. Representative Bickford, I take it you're here for Representative Edwards.
He's not here.
No, no. Okay, just to introduce it. And then I guess you
I
have,
did want to speak to the bill, so.
okay, so,
Hey, my name is,
oh, wait a second, I have to open the public hearing.
okay.
Okay. We're going to go ahead and open the public hearing on House Bill 1069 and recognize Representative Bickford for Representative Edwards.
Thank you, Madam Chair. My name is Representative David Beckford from New Durham, and I'm here to introduce to you HB 1069 as amended, which is relative to material subject to disclosure under the right to know law. Would you like me to go on, or?
Yep, if you can go on and take this time for your testimony.
Okay, I have some material to be passed out. One each. I think I gotta keep one though. Nope.
Whenever you're ready, Representative.
Okay. This is a combined bill. It has had another bill combined with it, which is the bill I started, which was 1069. And the Judiciary Committee decided to take my bill, take the guts of it out and put it into this bill. So I thought I'd speak to you about that. And that's on page 1, starting at 13 in the bold. And the reason that came about is because I went to a training session put on by the New Hampshire Municipal Association in the town of New Durham, which I reside, that they put on for the officials. And their attorney there said that you can't send electronic emails out. And I stopped and I said, well, wait a minute, how's that happening? And he says, right here in the statute. So I ran home and wrote a bill with the help of the legislative writer here, because it was that time of year, it was September 14th, as you can see. And that was the advertisement that went out for this class. So New Durham immediately on October 30th put out the next page underneath that, blue page. And it says, based on the advice of the New Hampshire Municipal Association, legal counsel, the town of New Durham will no longer provide electronic copies of documents requested under provisions of 91A. Document may be reviewed at the town hall once the request has been completed. Copies can be made and per page fees will be charged according to the town's fee schedule. So that brings us to a problem that was going around the state. And it turns out it was just that young attorney hadn't looked beyond the case law. And the other papers I gave you is the case law in 2016, I believe, yes, 2016, the Supreme Court said that, yes, indeed, you can receive electronic copies. And you'll see on page 6 and 7, the conclusions of that. So you don't have to read the whole thing. So, you want me to stop or go? Okay, that's a go. So effectively, what we're really doing here is trying to put the Green decision in case law into statutes, codify, I think it's called. And so that I can speak to. I know Judge Lynn and I had talked about the citizen being changed to person. So it's any person now. So take confusion out of that. I know there was, I don't know if Mr. Thorpe is here or not, but there was a newspaper that's just over the line, the state line, that does the Rochester News. And anyway, he wasn't able to get his news because, well, wait a minute, you're not a citizen. So he had to drive over to the town hall to get all his information. So he asked, well, how about making it so we can go over at least state lines and maybe beyond so that we can get our information. So that's how that came about. And there's more in here, but I'm not as familiar with the other stuff. I think it's part 2. So that's really all I have to say.
Very good. Thank you for your testimony. Any questions? Seeing none, thank you. Have a good afternoon.
Thank you.
Brendan McQuaid. Afternoon. Ken.
Good afternoon. Thanks for allowing me to speak again. My name is Brendan McQuaid. I'm a resident of Manchester. I'm the president and publisher of the New Hampshire Press, or the president of the New Hampshire Press Association and the president and publisher of the New Hampshire Union Leader. The gentleman mentioned is actually one of our publishers in our group. It's Harrison Thorpe. He runs the Rochester Voice and was told that he could not and was not entitled to town records because he did not live in town, because he runs the Rochester Voice, but he lives right across the line in Maine. And so he wasn't allowed to get those records. So the changing of person to citizen, we greatly support. Now, there is a whole bunch of other stuff in here regarding emailing, which as a press association, we love because our lives are email. And it just seems obvious that town should be able to email records. The place where I know this gets tricky is in out-of-state sort of corporate requesters that are data miners and things like that. So an earlier version of this bill had it as a permissive. Towns can send electronic records, and it's changed to a shall, which may be tricky and may need to be looked at. And may play hand in hand with HB 1002 that you guys are also taking a look at. But in general, we support the bill, and I welcome any questions.
Thank you very much. Seeing none, have a good afternoon.
Thank you.
Natch.
Thank you, Senator Nate Grace. For the Municipal Association, I did write a letter as well. We oppose this legislation. As already described today, it really does 3 things. It changes the word citizen to person throughout 91A. As mentioned, there was an incident involving a member of the press, obviously, understandably, state policy, adjusting state policy to reflect the fact that the press should have access to records is not something we would oppose. I'm not sure that this does this here because in conjunction with that change of citizen to person, there are 2 additional changes. The second one is that it requires municipal governments and other governmental entities to accept email and other electronic requests for records. That's, again, not that big of a deal. That's already done pretty routinely. And in fact, some governmental entities do keep track of that. I know the Governor Wentworth School District actually publishes online, and a number of requestors are simply email addresses. And the third one is that it requires New Hampshire's governments to send copies of records electronically if they have the technological capability of doing so. And it's really the combination of these 3 things that creates the problem, because we have situations where we could have out-of-state actors asking for information and then being expected to receive that information. And I would just remind the committee that there's really no nexus in this legislation to connect the responsiveness of government to the people the government serves. In Article 8, it's pretty clear that the government's supposed to be responsive to the people who formed the government, not to people in Massachusetts or Florida or California or anywhere else. And that's who we would expect to get records. We might expect that, a slightly larger pool than that. We would expect members of the press who do not reside in our state to also get records. That seems pretty reasonable. But that's not what this legislation does. It really opens up governmental records in New Hampshire, created for New Hampshire citizens, to anyone, anywhere. And that's where we run into a problem. There are a couple other things that I would mention. First, there is a provision in 91A:4 Roman 5, which was not touched by any legislation currently in front of this committee or contemplated by the legislature this year. And that provision does provide, I don't have a quote in front of me, but it does provide delivering records in a common file format. I think it would be necessary to harmonize that language at the very least. And lastly, in lines 23 and 24, it says no charge shall be made for records delivered electronically. Obviously, the intent here is to cover the cost of postage. There's no cost of delivery electronically, but assuming this committee supports the prior bill, we would hope that you would alter this language to clarify that at the very least. But even with those alterations, we still wouldn't support this legislation. I just want to point those out as technical defects. Happy to answer any questions that you may have.
Seeing none, thank you for your
Thank you.
testimony. Ms. Coco.
Thank you. And I'd like to acknowledge Mr. Grace as the representative of NHMA as the individual I forgot to mention in my prior testimony. So we worked together on that compromise and it went well. I will say that Right to Know New Hampshire is very supportive of HB 1069 and therefore in opposition to Mr. Grace's and NHMA's interpretation. As I've said, we've been involved in the formation of right to know related legislation for many years and have a number of participants who have experience with this, particularly some of the legislative and legal background on this. So I think it's important to understand that this bill does two things. It clarifies the standard for allowing individuals to request information under 91A, and it introduces routine 21st century business practices, notably the use of electronic communications, into the implementation of this law. I think regarding the replacement of the term citizen, I'm assuming it's been mentioned already. Everyone here is familiar with the Rochester case. In that case, aside from the media example, there are multiple reasons that a non-citizen may reasonably be considered to have an interest in information. They might own property, they might be paying taxes in a jurisdiction but not residing there in some other form other than property ownership. They may have children in a different school system from their community of residence. They may work in a jurisdiction where they somehow have a vested interest in issues related to transit or health. So I think the understanding of why it's important for this to be broader is key. What members of this committee may not be familiar with is the fact that under the Attorney General's 2015 Memorandum on the Right to Know law on page 39, and I do acknowledge that it has since been updated, that memorandum does not reference this issue in any way, shape, or form. I scanned it for the word citizen, and I believe personally that that was an intentional thing because of the cases that are before the state now. The AG noted in a footnote that 91A:4 refers to citizens, but the Right to Know law does not define this term and uses it nowhere else. Instead, the statute emphasizes accountability to the people, accessibility to the public, and the goals of a democratic society. An agency should not, therefore, require persons requesting access to public documents to demonstrate that they are citizens of either New Hampshire or the United States. But this is how public bodies like the City of Rochester included this is how they should be interpreting the current language that's in the law. Unfortunately, that is not what's happening. Replacing the language with the term any person will clarify what is already appropriate and recommended practice per the previous memorandum. What we have seen, though, is that since the U.S. Supreme Court case of McBurney versus Virginia in 2013, some public bodies in New Hampshire have been applying that ruling, which is a U.S. Supreme Court ruling, to their own situation. Right to Know New Hampshire believes this is being done in error, and the AG's footnote in 2015 confirms that. That ruling was based on a Virginia state law that very specifically details who is and is not eligible to get information in New Hampshire, and as defined by the AG's footnote, that's very different here in New Hampshire in terms of the type of language and the interchangeable terms that we use. Their stringent and detailed definition is unlike that. And in addition, the rulings from McBurney were narrowly focused on two issues: whether or not Virginia's law itself was in violation of the Privileges or Immunities Clause, and whether or not the Virginia Freedom of Information Act violated the Dormant Commerce Clause of the U.S. Constitution. In both cases, the court ruled there was no violation of constitutional rights based on the specific language used in Virginia, not in New Hampshire, not general language used nationally, Virginia. The language from this case cannot be used to extrapolate New Hampshire's less comparable statute, but despite that, because of McBurney and that idea that communities might deny records based on citizenship, it has worked its way into at least 2 local right-to-know policies that I am aware of, and it is part of a right-to-know training that is given by NHMA. The NHMA training says that information requests are only required by the town to be provided to legal New Hampshire residents, and acknowledges that there is no legal definition, but has a caveat that says this must at least mean that it is a New Hampshire citizen. Obviously, we disagree with that interpretation, and I think a lot of the information that's included in, or the changes included in 1069 are based on this issue of interpretation between NHMA and what the rest of the public is seeing in terms of how it's applied. That needs to be corrected. Regarding the use of electronic communications to transfer records, most communities have the ability to do that. They do so now. NHMA has commented, or made comments that anyone, anywhere could request those via an emailed request. It's already being done. There is no stated requirement in the right to know law that says the request has to be in a particular format. Most communities implement a policy of any request in whatever format can be considered a right to know request without having a specific format, and that includes emails. So I don't see that as a particular issue. And then as far as providing that information electronically, again, many communities already do that. They have the flexibility to provide it, but the ones that do not are the reason that this law is being proposed. There's a caveat in this bill that allows a community some leeway when it comes to something they cannot transfer because, let's say, the file size is too large. That's what they're doing now. But the communities that want to restrict access to information make that an across-the-board policy that they then require individuals to come in and physically ask for records. And we at Right to Know New Hampshire get those requests. I get phone calls from people. A good example, because the city of Manchester is one that implements this policy, was an attorney calling me to say, the city of Manchester is telling me I have to physically drive up from Massachusetts to come get information for my client. Is that correct? And we have to tell them, under the current law, they have the leeway to do that. That is a barrier to access to information. That is a fairly reasonable type of request, and we don't feel that that should be in place. People do business electronically now, and that's why this bill is needed. And I would also point out that electronic delivery of records costs less in terms of labor, not just for postage, but also for the amount of time involved. So I don't understand why a municipality would object to doing it in that manner. And that is what most communities do. They exercise their judgment. They say it would be more effective for us to send you these 3 or 4 files electronically than to go through having to have somebody come in or mail it or do it some other way. So, and I'm willing to take any questions. Thank you.
For your testimony. Seeing none, you're all set. Last up, I believe, is Henry. I won't butcher your last name. I should remember it, but I don't.
That's right.
Say it again for me.
Clementoach.
Okay, we'll work on that. Thank you.
For the record, my name is Henry Clementoach. I'm with the ACLU of New Hampshire. I recognize the irony of having printed maybe you'll find it a little annoying. It was not my intent to annoy you, but we support HB 1069. I think it's a common sense update to reflect the fact that we live in the digital age. There are a few towns, as has been said. I live in Portsmouth. City of Portsmouth is one that just has a policy. They will not email you documents in response to a right to know request. I think it's probably because they find that they get fewer requests, is my guess. But I don't think that's a very good reason to, in 2024, not mandate that people produce these records electronically where it's possible. I did just want to point out for the committee that there are a couple of carve-outs to the general requirement that information needs to be provided electronically. And that's if the public body or agency lacks the technical capability to do so, if doing so would be unduly burdensome, or if doing so would compromise the security of its record-keeping system. So, it's entirely possible that this could allay the concern that some have had about out-of-state companies coming and trying to scrape public data electronically. Maybe that would be unduly burdensome. But, in the context of, I'm looking for these 4 documents, could you please email them to me? I think this would mandate that happens. It saves everyone time, money, fuel. It's greener for the environment. So I won't otherwise gild the lily, but I'm happy to take any questions if there are any.
Thank you for your testimony. Seeing none, great day.
Thank you.
Does anyone else wish to testify on 1069 who I missed? Seeing none?
You done?
One to go. Last bill.
Oh, we're on the last one.
No, 2 more.
Oh, 2 more?
2 more.
Okay, I'm wishing and hoping.
Okay, thank you.
You don't sound like you feel it.
I'm okay. Chicken soup when I get home.
Oh, you got a cold, sorry.
That's okay.
I think we're ahead on time. Oh, no, she's not speaking. Yes. And yes. We're going to go ahead and open the public hearing on House Bill 1340 and recognize the prime sponsor, Representative Bickford.
Thank you, Madam Chair. I do have more handouts.
Thank you.
Okay, I am here as David Bickford, representative from New Durham, and I also represent Middleton. And I'd like to introduce HB 1340, which is relative to exclusion of incarceration as voluntary unemployment for purposes of calculating child support. This is one of the recommendations of the review, which you have the cover of here. Now, this is about 200 pages, and it's done by the Office of, or Bureau of Child Support Services. This one here costs $114,000. And it's done every 4 years. The last one before that was done by the University of New Hampshire, and that was $140,000. So we haven't been really paying too much attention to these reviews, and they're very important, very helpful. This one was done by Dr. Vanoa. She was the lead person on it. And it's to keep an eye on our child support guidelines and make sure that we're doing things appropriately. And they're here today to answer any further questions on the technicalities of these things. But anyway, in that review, you'll see I have a page underneath it, which I give you a little information about the review. But then there's a recommendation you'll see I highlighted in the middle of the page. And this is of the review, you'll find this on page 158. And it's recommendation number 8. And it says codified New Hampshire case law that does not treat incarceration as voluntary unemployment in New Hampshire practices to consider the actual circumstances of a parent when income imputation is authorized. This would bring New Hampshire in compliance with the 2016 added federal requirements to unambiguously comply with the requirement to not treat incarceration as voluntary employment. There should be no exception in the provision based on the reason for incarceration. And as far as the 2016 added federal requirement, that was a pretty big bill done, and I would recommend asking the attorney from child support if you want further information on that. Now, after that, I have the Supreme Court decision that Judge Lynn, at the time Judge Lynn, wrote. And if you go to page 3, I've highlighted that also. It says, however, this does not, however, preclude a court from determining that a parent has remaining sources of income, such as modification, is unwarranted. In this case, incarceration caused a substantial change in circumstances because he lost his employment due to his incarceration, had no ability to obtain employment while incarcerated, and possessed no other source of income. So what I'm asking for here is to just adopt the recommendation and make this case law into a statute and put it into statute. And you know what? I don't think they have anything else to add to that.
Thank you very much for your testimony. Are there any questions from the committee? Senator Abbas?
Just one question.
Yes, sir.
And Representative, thank you for taking my question. I understand what the purpose or intent of the law is, but let's say someone were incarcerated, and while they're incarcerated, let's just say they have assets that's in a, some type of portfolio that's earning 8-10% a year. They're still earning income, per se.
Yep. And
Interest, dividends, capital gains, by even during their incarceration time period. In a case like that, how would that then be impacted if this were to become law?
Looks like you're on that page. That was the first sentence I read. See the first highlighted sentence? Does that cover what you're talking about?
It addresses it, because I guess my concern is we're making a presumption that, yeah, they're no longer gainfully employed, so maybe that's subject for a modification, but they're still earning income while incarcerated. So when you have a scenario like that, how would this law impact that?
It won't. That's my understanding.
Thank you.
Yeah, that's why I pointed out that sentence before that, because if you have other means, then they can take that for child support. However, in the past, they were accruing child support for people that were incarcerated, and they had no other means. And so the Supreme Court said, no, you can't do that, and the federal government said you can't do that too. I'm pretty sure I'm right on that, in 2016.
Thank you.
Okay. Thank you, Representative Bickford. That was the question that I had, because this person, male or female, has an obligation to support their children. They're incarcerated because they've broken the law and they've gone through the whole court process. It seems from what your comments, what you've just said, is that they are relieved of their obligation to provide child support while they're in prison if they have no other means of support. So if that's the case, do you know what happens to those children? Because they don't go away. It's just this person, because they're incarcerated and they're not making any money that the court can determine, they don't have to do that. So it doesn't accrue behind them? Not at all? Well, okay.
No.
Okay.
It used to be imputed. I think that was the word. You would say, okay, well, you could have made such and such an amount of money, so we're going to use that and accrue it. And they just didn't work out, apparently.
So I just want to make sure I understand this. So if a person is incarcerated, say they have to serve 5 years, they have no other means of support, that family goes without 5 years of support from this person at all, and there's nothing. There's no penalties, there's no accrual of child support that's owed to the children. It's just basically wiped clean.
I believe that's correct, and that's what goes on now because of the Supreme Court decision.
Okay, secondly, once a person finishes their incarceration and they're back out in society, do they have to go to court again to reestablish child support? Or does the old order kick in?
I'm not the right person to answer that. I believe they do, because I think you'll find the Bureau of Child Support Services will
Okay.
act to bring them to court. But they're here to answer those kind of technical questions.
Okay, terrific. Thank
Okay.
you very much, Representative.
You're welcome.
Are there any further questions? Okay, seeing none, thank you. The chair will call Matthew Hayes.
Thank you, Madam
Good
Chair.
afternoon, Mr. Hayes.
Good afternoon. Attorney Matthew Hayes for the Bureau of Child Support Services. I'm employed with the Bureau as a staff attorney, and I also serve as a legislative liaison. So I have prepared some written testimony that I can submit that will include our viewpoint on the bill. We're in support of the bill, and the testimony will include citations to federal law and the case law that you were just discussing earlier. I think whatever's best, I think I can help answer some of those questions, and we can work our way through it. But I guess the Reader's Digest version for our position is we're in support of the bill because codifying that case law will bring us into better compliance with what the federal government wants us to do. The CFR, and I have the citation here, specifically asks that states in their child support guidelines include a provision that says that incarceration isn't, and I'm paraphrasing, but is not going to be grounds for voluntary unemployment. And as the sponsor, Representative Bickford, pointed out, the case law effectively says that in New Hampshire, but I think that, as I pointed out, to fully comply with what the Fed wants us to do, that needs to be codified. So I have that outlined in my written testimony. I'll just ask if you, I'll stop with that and answer your questions.
Thank you very much for your testimony. Are there any questions? Senator Abbas?
Thank you, Madam Chair. I don't know if you can just, you kind of touched on this, but I'm just kind of wondering what impact this would have if a person has multiple sources of income. Obviously, they may lose their physical job as one source, so it could be a modification per se for that.
Sure.
But if they have, I mentioned like a portfolio, capital gains, whatever you want to call it.
Yes. Well, thank you for the question. And I think that in our viewpoint, that portion of the case law, I think, would still survive. I think that this would only apply to a case where someone didn't have any income. And I think what the problem that is sought to be remedied is people throughout the country maybe coming out of prison with a lot of debt that they might not be able to manage, and that may help, but that'll hurt them in their ability to get back on their feet and go back to being productive in terms of getting back on with caring for the child, getting a reasonable hold on the child support order. And there's some good language. I have to defer the committee to take a look at the research, the study that was done, 2022 study that the sponsor pointed out, is that research has shown that having that ability to pay is important, and that's what we're trying to do. Is we want to make sure that people have the ability to manage the child support orders that they have while they can pay it. I want to say one other thing though. If someone becomes incarcerated and they have to bring the case forward themselves. They'll have to file a petition to the court. And if they don't, then it keeps accruing. And that can't be retroactively changed. So if someone has a $100 a week order that's ticking away and they don't get around to doing that, 2 or 3 years into their incarceration, the law says it can only go back retroactive to the date they serve that petition on the other party. So that can only be fixed when they do something. And if they don't have any other income, there's no portfolio or trust fund or anything like that, it's usually a minimum order. And the minimum order in New Hampshire is $50 a month. And when they leave incarceration, the standing orders and every uniform support order that's issued will impose an obligation on them to bring it forward when they become employed. And if they don't, usually, I want to be careful, it depends, but usually if someone doesn't bring it forward and they've had a job and the other party doesn't know and it comes to light later on, there are ways in which maybe an imputation of income can happen at that point. But in that first instance, as long as they're incarcerated, $50 a month is usually what happens. At least in my experience, that's usually what happens.
Senator Abbas, are you all set?
Thank you.
Okay. Are there any further questions? Okay, seeing none, thank you very much. Are there any other members of the public that would like to speak to House Bill 1340? Seeing none, close the public hearing. Okay, this one's really simple. Awesome. Okay, okay. We're going to go ahead and open the public hearing on House Bill 1341 and recognize the prime sponsor, Representative Bickford.
Thank you, Madam Chair. Glasses. My name is Representative David Bickford from New Durham. I'm here to
Thank you.
introduce HB 1341, and that is a repeal relative to the liability of grandparents to provide assistance. This runs down the same vein, and the reason I bring it forward, it's not a popular thing to bring forward, but it's another one of those recommendations from the report, and it'd be nice to clean some of this stuff up. So we picked up on a few of these. We haven't got them all, but there's a little more coming forward. These look like they'd be pretty easy to tick off. So again, came from the report, front page. Second page mentions the recommendation, which is in this case on page 157 of the study. And that is either repeal the law providing for grandparent liability to support the children of their unwed minor children or add more specification to it. There are numerous justifications to eliminate it. It is not a common issue. Child support from the parent, if able, should be prioritized. and establishing policies for consistent treatment would require a lot of time and resources for very few cases. More specification would entail whether to limit liability only to public assistance cases, application to both the maternal and paternal grandparents, identification of income to be used, and several other specifications. Now, there's 10 pages dedicated to reasons why we should probably do away with it. And I didn't want to read all that to you. And I know you don't want me to, but I did want to refer to you that in the study, they're on pages 120 through 130. Okay? And if you want, child support here to answer any questions, but it's really as simple as that.
Okay, thank you very much for your testimony. Are there any questions for Representative Bickford? Okay. Seeing none, Representative, thank you very much.
If any of you would like this book, it's available on the child support's webpage. And I was only allowed to have 3 of them. I have 1 extra if anybody wants it, but I'm hoping you'll get it from somebody else.
I think we can get a copy of it. Okay. Thank you very much, Representative.
Well, thank you. Here.
Are there any other members of the public that would like to speak to 1341? Okay, seeing none?
I didn't plan on speaking, but he's on here.
Are there any questions?
Well, second question, sorry. No, everyone's going to
Please
say.
identify yourself for the record.
Attorney Matthew Hayes from the Bureau of Child Support Services.
Thank you, Madam Chair, and thank you for taking my question. This RSA 167 colon 3-A, liability of grandparents, does this apply only when the grandchild's living in their the same household, or does it apply in other circumstances?
I don't know exactly how that statute would play out in practice. This statute really isn't something that's used anymore. From my research, it would seem that the statute exists at least at the outset because that child, the parent child, if maybe we can refer to them as that, isn't in the household. And I would think that if the statute were to be used, it would cover a situation where that grandparent doesn't have anybody in their household. But like I said, we don't use that bill, and I think that's part of the reason why the sponsor is bringing it, and that's why the study came to the conclusion that it is, because it's not used enough. It's not used anymore. It's not updated enough. The child support guidelines and the whole structure and the whole framework has moved beyond what I think that bill was initially intended to do.
Follow up?
And if this were to pass, we were to repeal that RSA. From the grandparents' perspective, how exactly would they have any liability, if any, and what circumstances would that be?
I don't think it would change any of our practices at the Bureau. I can't speak to every case that ever existed in the state of New Hampshire since 1961, but in terms of what we do at the Bureau, I wouldn't change anything that we've done. We don't use that statute anymore to hold grandparents liable for child support.
Thank you.
Are there any further questions for Mr. Hayes? Okay, seeing none, thank you very much, Mr. Hayes.
Thank you.
Okay, are there any other members of the public that would like to speak to House Bill 1341? Okay, seeing none, we'll close the public hearing. I'd like to thank you all for listening in today. We have concluded our business for the day. Take care, everyone.